Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay. Let's go to Detroit. This is a horrible one, but look, it's a short story. I'll tell you. I mean, the story is there's an accident where one fire truck is following another fire truck. I don't know that I would say that's at the alleged distance. It doesn't seem like it's enough of a distance, but in any event, and there's everyone pulls over as best they can, and unfortunately, a fire truck, the second fire truck, and this woman, now deceased, collide and cause obviously serious injury such that she's deceased. Mm-hmm. The trial court dismisses the case, dismisses this wrongful death suit as against the city, and it's the husband suing, right? But dismisses it against the city. The Court of Appeals reverses and says, listen, there are too many questions that should have gone to a jury before we conclude that immunity does apply or does not apply. And the trial court should not have dismissed this, finding that, there is immunity, et cetera. And this is certainly going to be the norm in driving cases. They are going to go to a jury question, unless there's a video of the whole thing. There's generally going to be a jury question. So they're ripe for trial, which is why, just so everyone knows, off topic, a lot of lawyers will take a semi-sucky case because they're saying, you know what? You really want to spend all the time going to jury? We'll try this right up to the jury. Maybe we'll find a sympathetic jury, or 5 out of 6 jurors who are sympathetic. That's what you need to win in most cases. In any event, this isn't going to go away. Normally, you and I predict whether the case will go away. This isn't going to go away. There's too many factual questions. And once a lawyer hears fact question, now all I can do is convince a jury. But there's a more interesting statement in this case that I want to highlight, because here there is a question and a probability that an internal policy was violated by the driver. And the court makes a statement, which is very important for people to understand, because it's not universally true. This would not be true in New York State, certainly. And I would think this what I'm about to tell you in Michigan is the minority rule. But here they said an internal policy, violation of an internal policy, is not proof of negligence. Mm-hmm. And it may not be, but what they say is that
but it's evidence of negligence.
It's evidence of it, but it's not proof.
It's not
two different words, right? It doesn't establish negligence. It's some proof. But what the court goes on to make a point, which is again important, which says the policies are implemented for the benefit of the department, not for the public, and the public cannot rely for lawsuit purposes on violation of a policy. Now, that does, right? And here's what the court says, which is very true. When there's a law that governs how you drive, the fact that there's a policy which changes, kind of shrinks the law, right? That is not able to be used against them. Let me put this in terms when I give the must-have policies lecture. What I tell everybody is, listen, don't call these policies, call them best practices, because best practices, as this judge says, are not admissible in court against the department. Why? Because the law says that you've got it. Here's the standard of care right here. And you aim high, like the old Air Force, right, thing, aim high. And you aim high with the best practice. And the law says, even though you establish this as the best practice, we're not going to hold you liable for failing to get up here as long as you've met the standard. Now, I would suggest that the judge here actually got it wrong, however, because a policy which leaves no discretion on what how the person was supposed to act, we know that policies can be used against you. This may have been interpreted to be a best practice, but violation of an internal policy can lead to liability. We've seen it on a million occasions.
Well, you and I disagree on this, okay?
I love it.
And no, it is. And I think that sometimes as lawyers, we get so focused on the legality of it. And here's the reality. The purpose of a policy is to prevent this accident from happening.
Yes.
Okay. Once the accident happens, all the things that we're talking about here are like rearranging the deck chairs on the Titanic to make it look like we were doing things right.
Right.
The purpose of the policy is to make sure that accidents don't happen. And we can't water down our policies and make accidents more likely by, sort of rearranging the language. That's, to me, it's the same as rearranging the deck chairs. I'm actually working on an article on this, so that's why it's on my mind. And I really think that sometimes we miss the boat. We're so worried as lawyers. We're so worried about trying to protect our clients from liability that we can put things in, like we say, oh, don't say shall. Oh, right. Never say shall, never say must, Well, you know what? Stop at the damn red light. Okay. And if you're going in the wrong lane of travel, this is what we want you to do. And another aspect here is when you're following, and one of the first things I had to do as a safety officer when I became a safety officer in Providence back in 1991, and I started really studying the accidents, and we were having a number of accidents, and it was typically the second truck that was going through. And there's a lesson there that the first truck, usually people recognize. People driving their personal vehicles are in la la land. They're out to lunch. They're condition white, whatever you want to call it. They're not paying attention. They're on autopilot. And when they hear the siren, they pull over. And then the next thing they do is they pull back into traffic. And as a second vehicle, you have got to be looking for that. You have got to be paying attention to that.
But they don't know, right? The second vehicle knows, the public doesn't know. So you're right.
And they hear the siren. They assume the siren they hear coming from behind them is the same one that just went by them. So again, there's lessons learned. Our policies need to reflect those lessons learned. And we can't be worried about having a good defense after we kill somebody.
Right.
Great. And, you killed somebody, but we're going to get you off. No, that's like saying it's okay to run a ship into an iceberg, kill 1,500 people as long as you're not going to be held liable. No, we have to figure out a way to avoid the iceberg.
Unfortunately, here, though, we aren't disagreeing because, and as more exciting as it would be if we were, because there's a difference between a policy and a practice, the way I teach it. And the policy is non-discretionary. You will do it the same way every time. The best practices, when I say, okay, make things best practices, is only when it's, for example, the example I always use, the first engine should hit the hydrant. Yes, because you're not going to do it every single time unless there's no discretion. I always want the first engine to hit the hydrant. With driving, there should never be any discretion. You shall, quoting the NFPA, you shall stop at every controlled intersection. You shall stop at railroad tracks. You shall, There's no discretion. You shall not speed by X, whatever, even though I don't love that one. But if there's a conduct, you shall not overtake a vehicle. You shall not follow close. There's no discretion because the traffic's never going to change that you should be violating driving laws or your driving policies. So I don't want anyone to think that I would have driving policies not as a policy. I would always have driving policies because it's every single time, all the same way, never discretion. Things like firefighting, Oh, we're going to do whatever, vent, enter, search on every second story. Discretion. Those are discretionary. How we fight fires.
One of the things that I'm working on this article, like I said, and I want to go back in time. In the lawyer's office, the lawyer who represents the Titanic's owner. Okay. And the Titanic's owners are proposing a policy that says that the ship's captains shall take a southern route to avoid icebergs. Shall. And the lawyers are like, you can't put shall. Oh, no, don't put shall. Make it best practices. Let's not call it a procedure.
Right.
Because we could be held liable.
Right. I agree. If you expect conduct, it goes in a policy.
Right.
If you hope for conduct, I put it in a best practice. right? And right, again, the hydrant one to me in a small department or smaller department, you're not always going to be able to hit the water and get water, or there's going to be someone hanging out, right, of the window, and you're going to be like, okay, right? So if I don't want discretion driving, wearing a seatbelt, don't touch people like you shouldn't be touching them, right? All these things. There's no best practice on sexual harassment, right? You should not do things. You should not grope people. There's no should.
You shall not.
Shall not. Okay. Yeah. So here, though, what's interesting, back to our point now, is he assumes it's a policy, but still says it's not admissible, which I frankly disagree with.
Oh, okay. I didn't see that part. I thought he basically said that it was it's evidence of negligence, but it's not. It remains a question of fact. Violation of statute. I see that. He's saying violation of statute is evidence of negligence.
He says, in other words, a defendant's violation of its own internal rule, even if the rule is designed to protect the public, does not constitute negligence per se. We agree on that.
Right. And just so everybody understands, right, we do. No, negligence per se for the non-attorneys out there means it's a done deal. I mean, you are negligent. Negligence per se. And there are some states where violation of a statute is negligence per se. But I think the better rule is this is all evidence of negligence. Your policy is evidence of negligence. The statute, testimony of experts, and all the different factors that go into it are all evidence. And then the jury has to sort of figure it out.
Right. But I really think that this judge has kind of mashed a couple of things. In any event, look, just so the viewers understand, Curt and I are on the same page saying if you expect conduct to happen, then you better write shall. I have a case right now with an EMT in front of the state. The state's charging him with a violation of policy. And yet the policy says should in most cases. Well, guess what? We use discretion. You can't discipline us on using our discretion. You invited us to use our discretion. Well, that's a best practice, maybe, but that's not a policy. Policy shall, will, and must. That's it. Okay, so I think we've beat that up, but I thought that was the more interesting part of the case than, hey, there's a question of fact.
I agree, and again, from an operational perspective out there, we've got to recognize that these types of accidents are happening when you're not the first truck in line. I mean, certainly there's risks that are with the first truck, but there are specific risks with the second and third trucks going through an intersection. So you can't assume because people they're out to lunch, they're on autopilot, and the truck went by. I'm thinking about, I got to stop and get milk on the way home or whatever, and they see the truck go by and they're pulling back out, and that's a risk.
And look, while we're on it, let's just say it's not just the public. When we have two fire apparatus or emergency vehicles going to the same or different calls, and they come to the intersection, seeing everybody stop, assuming they're stopping for them, and you don't stop and make sure the intersection's clear, and one or both of you proceed, you run into each other. And that's definitely not rare. It's happening, right?
I went through a case representing somebody in a situation like that, and we could not convince the department that was the real problem, and they needed to train their people on it. They wanted to just blame one of them. And I think that was foolish, absolutely foolish.
There was an issue in Orange County, New York, where a truck was coming out of the city of Middletown, but a truck, right? In firefighter terms, a truck with ladders. And a squad, or a chief's vehicle was going the other way. They were going to separate calls. They both thought they had the same, both thought they had the control of the intersection. Neither knew they were coming. They just, hey, everyone stopped and pulled over. They both went. Fortunately, the squad hit the truck, not the truck hit the squad. It would have been a very different outcome. But this definitely happens. And I was never, Curt, I will tell you and the viewers, I was never in favor, because New York law only requires that you slow down. I was never in favor of the law that says you shall stop at all controlled intersections, but I think that's the better policy.
I think it is, and I mean, I'm very deliberate about that now, very, very deliberate when I'm responding. But I know earlier in my career I was not, but I am. And the scenario that I had to deal with involved a ladder company coming to an intersection, makes eye contact with both drivers. So you're coming up to the intersection, you look to the left, You see the driver sees you and acknowledges, they stop, the driver on the right, they start to proceed, and you got an engine company coming in the wrong lane at a high rate of speed. They did have the green light, but again, this ladder company had eye contact, visual eye contact with both drivers, and it was not good.
I mean, we could tell stories all day, but I will say, Nicole and I, when we were at FDIC 2 years ago, we're walking to a restaurant or something, and all of a sudden you see a police caravan taking the Pacers or somebody in their buses. So the police officer comes up, stops the intersection, and buses are going by, but they don't come up yet immediately behind them. So the police officers just got the intersection. At the same time, an engine from the city is coming a different way.
Oh boy.
We thought going to the same call. We didn't see what happened. And then the engine and the police almost collide. Actually, the police left, moved. The engine thought they had the intersection, thought the cop had the intersection. Now all the buses start coming through, and the engine goes almost up on two wheels, right? And we're like, this is going to roll. It's one of those, oh crap moments, all because everyone didn't stop, right? So these things happen far too often not to be following your recommendation.